On one end, the rules in the US used to be first to invent, so startups could just document when they invented, and if someone filed before them, they could show that they invented first and have priority. That's changed, and now it's a first to file system, so it's more important than ever to file your application as soon as possible. And on the other end, there are the deadlines that I talked about. If you're interested in international filing, you've got to get that first patent on file before you publish the information. And in the US, it's within 1 year of that publication date. And in the US, they also have this on sale bar. If you start to try and commercialize the invention that's been ready for patenting, even if you didn't patent it, you know the information, you've worked it out, and you start to commercialize it, that starts a clock ticking that you've got to file within 1 year of that date. And the policy behind that is they don't want you to keep something as a trade secret and keep the option open to file it and try to commercialize it at the same time. So once you start to try and commercialize your invention, you've got 1 year to make that decision. Either you file it or you give it up and you keep it as a trade secret if you can. But of course, some things are not you can't keep as trade secrets because the minute you start selling it, they can see how you did it. So you really can't, so there are some things where that's not even an option. But so it depends on the technology. So between those two dates, there's a date where you can't go past, these bar dates, and there's, the day after you come up with the invention, you could file an application. And there's some considerations. Obviously, budget. People are always trying to, when they have a startup, to get the funds to file the application or do it themselves. And the other thing is, there's kind of gray areas about where you are at in your invention. Sometimes you have the concept, but the requirement is that you teach someone how to make and use the invention without undue experimentation. And the idea behind that is if there are difficult engineering issues that you haven't really worked out, and there's a lot to be worked out, you think you invented a time machine, but you don't really know how it's going to work. You can't get the patent, it's going to fail for enablement. The idea behind giving you the monopoly is that you're teaching people how to use it in exchange for that monopoly, and if you've got all these questions and unsolved problems, you don't deserve the patent and it's going to be invalidated. So that's the judgment call. You want to file as soon as possible to beat others to the patent office, but you also want to wait till you have the most obvious issues worked out. And of course, during the development process, you may find out that this idea you thought was really valuable turns out not to be the way to do it. There's a completely different way to do it, and if you could go back in time, you wouldn't have filed that application. And so that's always a possibility. You've got to judge, how possible that is in making that educated guess about whether to invest in the patent. Sometimes you learn more information to make it better, and you may have to follow up with another application to include that content to be able to file it. And so those are the considerations. Sometimes you want to file a sequence of patents. So there's such a thing as filing too early, and there's such a thing as filing too late. So it's something to keep in mind. And in terms of the publication and the commercialization, you want to talk to a patent attorney early, make sure you know when you've triggered that date, and maybe some ways you can avoid it. Obviously, NDAs are one way to avoid it. Maybe it's not so obvious, but that's not a publication. If you talk to someone under an NDA, it's confidential, and so that may stop the clock from starting when it otherwise would if you didn't do it under NDA. So, okay, so that's kind of the considerations that you should be playing with in your mind about the timing. But I think it's always helpful to not wait till the last minute to talk to a patent attorney. Even if you're not ready to file anytime soon, sometimes it's helpful to talk about your situation so you have a sense of the timing of things, the events, what you might do to extend your options, to delay filing, et cetera, et cetera. You can touch base with them, kind of figure out what you're doing, and then check back with them periodically as you get closer.